Okay, we've been talking about strict liability, and we talked about ultra-hazardous activity, and then we talked about animals that may cause you liability, become strictly liable for, and we talked about product liability. And the last thing we talked about in product liability was design defect, and that's pretty much where we left off at last lecture. So the seller could have avoided or reduced the foreseeable risk of harm by adopting a reasonable alternative design. And I said one of the classic cases is, of course, the Pinto case. But there are other cases that are rather interesting. There's this case involving an airplane that was too high in the sky, and it basically was falling out of the sky. It was a new airplane, and unaccountably it was falling. It was having too many crashes, and they were blaming the pilots for the error. But then they realized it was a lot of crashes, and so they took a closer look at the design of the aircraft. And what they found was that there was this new plastic tube that ran between the tank, gas tank, and the engine that carried gasoline. And what was happening with these planes was, it was all right as long as the gas tank was more than half full, but if it was less than half full, and if it was above, like a mile and a half up in the air, so if it was flying at a higher altitude, it would, the gas tank, the plastic hose leading from the gas tank to the engine would collapse, causing the engine to stall and die. And so the airplane would go crashing, plummeting towards the ground, because there's no power. So it would be plummeting towards the ground. Sometimes pilots were able to restart the engines, but a lot of times these planes were crashing, terrible crashes with many people dying. And once they figured it out, it was a simple fix. They just needed to put in the alternate design. They just needed to put in more of an aluminum tube that would carry the gasoline. But it goes to show you, and there had been aircraft inspectors going out after each of these crashes, and they always had come to the conclusion it was the pilot error that was causing the accident. So there are lots of interesting kind of cases. There are cases involving the design of medicines. And so nowadays you have cases maybe designed with genetics, and genetics is going to be a big thing in terms of medicine relatively soon. Already it's helping a lot of people. Communications defects, we talked about that. Seller could have avoided or reduced the foreseeable risk of harm by providing reasonable warnings, instructions, or advertising in a manner to avoid misleading. Either omission of an instruction, warning, or wording of the communication makes the product unreasonably dangerous. And so, you could have a bad warning, a warning that's not really actually providing the kind of thing, or just the absence of a warning. Maybe something needs a warning that didn't. And we'll see a case like that where it was alleged that you needed to have a warning placed on a car that was otherwise okay, but you needed to have a warning placed on its fan blade. So the parts themselves may need to have warning stickers, and the warning has to be adequate to warn people what it is. The labels sometimes can confuse people. So I saw here in Muncie in a store back in the 80s a container that said lemon fresh. It appeared to be a liquid, but the price of it was way below other lemonade, and so I got suspicious. And then I realized that it wasn't lemonade at all, but it was some sort of cleaning compound. But all it said was lemon fresh. It had a picture of a lemon. Didn't say anything about what it should be used for. It didn't have a list of ingredients. But I decided that. I read later in the Muncie newspapers that some people had been admitted to the Muncie hospital after having imbibed lemonade that was supplied to them that was made from this particular bottle. And so that was misshelved. That bottle was put in the shelves with the lemonade. So be careful. Sometimes people will make those mistakes. You need to look at it very carefully and be suspicious if the bottle doesn't appear regular, if there's something peculiar about it, like you can't see the ingredients, then it's probably not something you want to take or imbibe. And that would be the case then. Okay, so, and we talked about the fact that, you need to have your instructions clear. You don't want Pop putting together a bicycle in a way that makes it dangerous because he's drunk. Okay. Okay, so let's move on to defenses to product liability. Of course, the basic defense in any sort of tort is actually a denial of injury. It might be a denial of responsibility. That is, you might deny that there is any sort of duty in a negligence case. You can deny that you were the probable cause. These are very straightforward defenses. You would answer them in your complaint that way, and then you would try to show that in fact there was something wrong with the complaint charges. So denial of injury. The plaintiff wasn't injured, he's faking it. I remember that there used to be this thing called whiplash that people used to do, and it became kind of like something that was worked into comedies a lot, where people would be claiming in comedies that they had whiplash because it's very hard to prove or disprove that a person had whiplash, which was some sort of injury to the neck. And so there was oftentimes movies that were made on something like that. So sometimes some things might be claimed as injuries that aren't, and so persons might have to submit to examinations by doctors that are not their own doctors. Responsibility. That is, you claim that you didn't have a duty. So Ford, I think I mentioned you the fact that when Ford was sued for the Pinto, it tried to claim that it wasn't responsible because it had no duty to produce a car that was as safe as a tank. Well, nobody's asking. The standard is not that. You have to look at what the duty actually requires. In this case, the duty would require them to make a car that was reasonably safe, not ultimately totally safe, as a tank might be. That's shows you how these claims are just kind of come and go. Cause, there are sometimes there are defenses for causes. One very common one might be in a negligence case to allege that it was an act of God. And so the dam breaking, was that an act of poor workmanship, or was that an act of God? Should the builder of the dam be responsible if somehow God was the one who did it? So was God, putting an unusual amount of water in there, and therefore that's why it broke? And do we want to recognize that as an act of God? The court in the Ryland case did not recognize that as being the defense. Okay, there's a couple of interesting defenses. One of them is well-known danger, very similar to commonly known danger. So well-known danger and commonly known danger are pretty much the same thing, in which case you don't need to have a warning. However, sometimes it's a good idea to have a warning anyway. And so the better practice is, if you know that people are being injured, you might want to tell them about this. So I remember one case involving a man who had purchased a bowl of clam chowder, clam soup, basically. Okay, and as he was eating his soup, he punctured his gum with a clam shell, which was in the soup. And you say, well, that shouldn't be in the soup. Well, that's probably true. But the court said, well, anybody who eats clam soup must realize that there may be clam shells in it, and therefore is assuming a risk. It's a very old case. I don't know whether that would hold up today. There was in Indiana here, we had a case involving a lady who actually was eating steak, and she'd bought the steak at a grocery store. I won't name the grocery store because I'm sure it's not necessarily something that they frequently have happening. But actually what happened to her as she was eating the meat, the steak, her throat got punctured by a needle, and it was a broken needle. So apparently, I guess what had happened is somebody had tried to put some sort of needle, shoot some sort of medicine maybe into a cow, and the needle broke off. That could also be a sign that maybe they were trying to make the cow fatter by giving it hormones. Who knows? But anyway, it's kind of remote, isn't it? Should Kroger be liable for that? Is this a defective product? Well, yes, I think you can say it's a defective product. But remember, the standard is that you can be held liable for sale of a product that's defective if you're a seller. So that's the risk you take as a seller, that you're responsible for anything that was there when you sold the meat. And so she sued, and I think that clam case would indicate a different kind of outcome. But in this case, she won. Court said that one needs to be aware, even though another defense might be that might have a statutory defense of it's been inspected by the Food and Drug Administration, right? So it's safe. Well, even though it's been inspected by the Food and Drug Administration, if it's a defective product, you can still hold them liable. So that was, we started off talking about clam chowder and it being a well-known danger. Then again, it's not a well-known danger that there could be a needle in your steak. So maybe that's the difference. If you're working on machinery, it's a commonly known danger. Many people realize that if you're working on machineries that have a lot of moving parts, you need to have your hair tied up in a bun if you have long hair. Anyway, this one worker didn't tie up her hair, and what happened was her hair got caught by the machinery and she was dragged into the machinery, injuring her head. Okay. Very terrible, awful kind of thing, I'm sure, to experience. And the court held the company liable anyway. It actually held the manufacturer liable anyway. It seems that there was no warning on the machine. The manufacturer of this particular machine had said that there were warnings that were put into the machine that were there, and that it had just been left out by accident. And so she didn't get the warning, and the court found that she could recover because the manufacturer didn't put the warning on it. So I guess if you're making a product and it needs to have a warning on it, you should probably not, it was supposedly something that they had shipped with the product with instructions on where to put it on the machine. But nobody at the plant put it on the machine, so, I guess, you could argue that they should be somewhat liable, but the manufacturer maybe bears the primary responsibility in that case, is more likely the proximate cause, and could easily have avoided this by simply putting it on. A similar case involved a man who was operating a punch press machine. A punch press machine, there is a steel rod, rather big, about the size of a big baseball bat, okay, that comes down and punches hole. Now you can get different parts that you can put in there to change the metal. So the punch press machine comes down. You lay a piece of metal, flat piece of metal, on the base and of the machine, and then when you press the button, the ram comes down and strikes and makes an impression on this metal. So it's a very powerful machine, and the metal that comes down is very powerful. But one of the dangers that exist in that is that people who operate the machines are oftentimes paid by the piece. That is, they get paid more money for more pieces. If they produce a lot of pieces, they get paid well. If they don't produce as many pieces, they don't get as much. There's a certain amount that they have to make, but over a certain amount they begin to get extra money. Anyway, so some of them try to find ways to increase, and some of them are they're hurrying to actually do this, will actually injure themselves. But there's things you shouldn't do. Now, some of the machines will have straps that are put on the arms that when the rod comes down will pull arms away, and arms and hands away from the strike area. Okay? and those work fairly well. But of course, if you don't use the arms, you could get injured. Or another way is to have two buttons. Okay, so you put the metal down, and then you want to press the buttons, and the buttons are on both sides of the machine. You can't press them with one hand. You have to put one hand to the left of the machine, one hand to the right. It's on the sides of the machine, and you have to push both those buttons, okay, at the same time. And therefore, if you do that, you cannot lose anything, right? You're not going to lose anything to the punch press machine. What people will sometimes do is they'll tape one of the buttons down, which of course then eliminates that safety feature. And although I'm sure they don't think that they're going to lose a finger, a thumb, a hand, an arm, they wind up losing oftentimes these parts. And you know, I used to work in an area where they had punch press machines, and I didn't work in the punch press room, but I would go by there and I would sometimes see people who worked in there, and they were oftentimes missing things like hands and arms. And you know, they gave me an opportunity. I could make more money if I worked in a punch press machine. I said, no thank you. You know, I guess with these safety features, as long as you don't try to override them, as long as you don't try to produce too much, as long as you don't get greedy, they're probably perfectly safe. If you tamper with them, you have committed assumption of risk or contributory negligence, actually both, right? Because this is an unreasonable assumption of risk. There are also other defenses. So waiver and disclaimer are things that you could use. The warning can be used. You know, there was a warning and the person ignored the warning. We talked about that earlier. Disclaimers and waivers and warnings are defenses that can be used. Waiver would be that the person who is injured has usually signed some document eliminating any liability to the person. So a racetrack might require people who want to drive in the races on the track to sign a waiver that they will not sue the racetrack should they be injured during the races. Now, what is the result of that? If you do bungee jumping, again, you will sign a waiver, you know, saying you will not hold them liable. Same way with riding the mechanical bull. You sign a waiver, and only then can you ride the mechanical bull. And I think the mechanical bull actually is probably not as dangerous as they made it out to be in that one movie. And I also think that the people who operate the machine are typically people who are chosen in a way that they will not cause people to fall from it. They're not really trying to get people to fall from it. They want to give people a thrilling ride. So for some people it might be a little more challenging, but if you know how to ride them, they'll figure that out. The person who runs it, you know, I'll tell you how to ride them. If you climb up on the mechanical bull, once this starts, its head the front of it may go down. And when the front of it goes down, you lean back. When the front comes up, you just sit up straight. You don't lean forward, you don't lean back or anything. You just keep your posture. You know, the idea is to stay vertical. And if you do that, you should be okay. Now, the other problem might be that you might injure yourself if you try too hard to hold on to the saddle or the reins, because a girlfriend of mine did that and she injured her wrist. And that's why they have you sign the waiver, right? But the question is it an unreasonable risk, or has the track actually failed in some duty it has towards people? So, for instance, a racetrack here in Indiana had these waivers and had the drivers all sign them. And one time, when the race was going on, they had to call all the cars off the track because there was an accident, and they sent the crew out to clean up the track, supposed to collect all the debris so there wouldn't be another accident. And the crew missed a big part. That is, they left the engine in the track. And so then somebody waved the cars back onto the track. Somebody goes roaring onto the track and runs into the engine and has a wreck, sues the racetrack. And the racetrack, despite the fact that it had this waiver, was found to have had a duty of safety to all the drivers, and therefore was not allowed as a matter of public policy to use that as a defense. So you can use them as a defense, but oftentimes you're going to see it works best when usually the person is being unreasonable and doing something that he shouldn't be doing anyway. So if you combine that waiver with the ideal that the person has been unreasonable in the way he was proceeding, then you've got a better chance. But if you wave the guy onto the track, he's got every right to believe it's reasonable for him to go roaring out there, and he may not be able to see the engine. After all, the crew didn't see it. Anyway, yeah, as long as it's not against public policy, you can have a waiver. Usually they work better with financial losses. I think they might work much better with financial losses. They tend to be called against public policy whenever there is a physical injury. Bungee jumping is the same way. What happens if you go bungee jumping and the rope snaps or breaks, or the noose slips off? You could probably still win against the providers of the bungee jump. They have a responsibility to make sure that their equipment is in good condition, and that their people know how to properly tie knots. And if they haven't done that, then as a matter of public policy, the state, whichever state you want, most states would clearly, definitely declare it to be, the bungee jump's fault if that happened. So that's waiver. Disclaimers similar to that, oftentimes a little more specific. They disclaim a certain specific kind of liability, whereas waivers will tend to be a little more general, any liability. Anyway, state of the art. Let's go back and talk about the airplane that crashed. One of the defenses that the aircraft manufacturer raised was that he had, hired competent engineers, and the plane was state of the art. That is, that it was as good as any airplane made at the time as they could know how to make a plane. They didn't know at the time that this plastic hose would collapse. No, they hadn't had an experience with that, and so they claimed that it was state of the art. They had actually had the plane tested at that altitude, but it didn't collapse because more than likely it was flying with a full tank or more than half a tank of gasoline, in which case the air pressure was still high enough because the gasoline helped to keep the air pressure high. That was what was closing off the valve. So that's the state of the art. Now, just because they have a state of the art defense doesn't mean you can't challenge it. Now, where this comes in very handy is actually the pharmaceutical industries. They make medicines, and oftentimes they're making medicines that are new, and often these medicines are made as safe as possible, and they're maybe heavily tested by the government. Still, this may be possible to sue them if there was any things that they didn't disclose. So if you can show that they weren't disclosing things, or they were lying about things on their applications and such, then you can get it. So there was a lady named Theranos, a young lady, and she claimed to have a machine that could test blood, and for various purposes, for people who were diabetic, people who needed to have blood thinner, that her machine would test all this blood and tell them the information they needed. In truth, it wasn't that reliable, wasn't that good, but she falsified all the information. And when they came to test it, she would have the test done on her machine, but she would also run the test out to other labs to have them run it. So she was winning, and she was misleading the people who were trying to test it to see if it was ineffective. Eventually she was found out, and of course she was charged with criminal acts and sued, and her company just went under. She had big names of people, Charles Schultz, who used to be an economist, a head economist for the Bush administration, I think, and others who were very, very prominent. So this happened in the early 2000s, or maybe later 2000s, and it was a big fraud. She had worked out a deal with one of the pharmaceutical companies. I forget whether it was Walgreens, CVS, or some other one. I don't know which one it was. And they were going to do that, but it all fell through once it was discovered that she was lying. She had big plans of making all kinds of money and had received rewards for being a brilliant kind of entrepreneur. Okay, entrepreneur of the year, right? Okay, kind of reminds me of the financial officer at Enron. You know, Enron was a terrible financial scandal, and the financial officer, the chief financial officer, CFO, was Andy Fastow, and he was awarded awards for his innovations. And later it was found out that his innovations were just simply a matter of cooking the books. That was the only thing he was innovating. And so you have this kind of problem that could happen. So you know, these defenses are only as good as the people who assert them, and if they were lying in the first place, then they won't be able to use that kind of defense. So we started off on state of the art. I should talk about intervening causes. Intervening causes are things like the act of God. If you you know, if you can't prove, if it's an act of God, it means that it's not, the proximate cause is not the manufacturer of the product. And so acts of gods are things like, you know, hurricanes, earthquakes, you know, lightning. So let's say your car is some way defective. The question is, did the car cause the accident, or was it that? So your car is defective. However you've been driving around, the defect hasn't affected it, and it didn't affect it when you had your accident. What did affect you when you had your accident was you were hit by a bolt of lightning that threw you into a tree, and so that was it. So that was an act of God. So if you can prove that it wasn't your defect or your product that was defective that was the cause of the injury, you have a perfect defense, because they have to prove proximate cause, whether they're bringing strict liability case under product liability or whether they're bringing negligence case. You still have to, in both of them, you need to show proximate cause. And so act of God is a very good one to get out of it. And of course, in a lot of cases, even with negligence defenses that maybe were not available against strict liability can have been used now, especially when you have a statute that says you can use it. So Indiana's statute of comparative fault says that you can, that a manufacturer, a company that's allegedly acting ultra-hazardously, or even maybe the owner of a dog, can allege assumption of risk and contributory negligence as defenses. So you can use those. So basically, intervening causes come between your causal act. You know, did you do something that could be seen as the proximate cause of the injury? So one example I use is you're speeding along in your car to get somebody to some destination in a hurry because they're late to get there and they need to. They're interviewing for a job and you're helping them out, but you're speeding and it's raining and your car gets hit by lightning and thrown into a tree. Was it your speeding and you know, the slippery road that caused the accident, or was it the tree? It may be a combination of both, but if the jury comes to the conclusion it was just largely the act of God, then you're off, right? So intervening causes, that's what we call that kind of defense. You know, and it could be used in negligence also. You'll find that, you know, intervening causes is the way to maybe defeat a claim. You know, it's basically saying that they haven't proven probable cause. If not defeat it, maybe you can get them to lower the amount of money that you have to, that they have, that you're entitled to, or they can do that. They would want to do that, not you. Anyway, intervening causes. Now the last defense, I got an interesting story about the last defense, is misuse. Misuse arises whenever you use a product in the wrong way. So oftentimes people will use things in ways they shouldn't. So my favorite case involved two attorneys that I know, and they were on either side of this case. You know, and the manufacturer's defense was misuse. And so what it was, Taylor had gone to a junkyard and had picked up a, a fan blade that he installed in his car. The car, when he got it on the highway, began to make noise. He lifted up the hood. You shouldn't pull over the side of the road and lift up the hood on the expressway, which he did. He lifted up the hood, and just at the wrong time, the fan blade broke off and lodged itself in his chest, killing him almost instantly. His widow and children sued, and their attorney alleged that it was foreseeable misuse because GM alleged it was misuse. You know, he had gotten it from a Pontiac car and then put it into a Chevrolet car, which generated more torque, that is more speed, more centrifugal force than the Pontiac could have, and that's why it broke off. And so the plaintiffs alleged that it was foreseeable misuse because GM knows that people go out and get these parts from other automobiles and put them in their cars. That this is a very common thing for amateur mechanics to do. Even maybe regular mechanics may do this. I know that I've had regular mechanics offer me parts at a good price because of that. So basically, the defense is one of foreseeable misuse. You know, unforeseeable misuse. You know, it's got to be unforeseeable in order to meet the requirement that you be the cause if you're the manufacturer. So if it's foreseeable misuse, then the manufacturer needs to do what? Well, he needs then to put a warning on the car telling people not to put this fan blade on engines that generate a torque in excess of, you know, technical information, which hopefully even the amateur mechanic might take note of and say, well, maybe I shouldn't put this on there. You know, maybe I shouldn't use this as a substitute. And obviously, if they put more information on these parts, it might actually prevent some accidents from happening. Anyway, that was a decision that could have been decided by the judge. He could have taken that as a matter of summary judgment and decided. And if it had gone up to the Court of Appeals, they may well have affirmed his ruling. But he did not. And if you think he was some wild-eyed liberal judge, you're mistaken. He was appointed by Reagan, and he was a conservative, but he thought that, you know, he was going to leave it to a jury. Many conservatives believe that you should leave many decisions to the jury because that's the democratic process, isn't it? The jury is a pillar of democracy, so said Blackstone. And Blackstone was a big influence on the founding fathers' conception of what jurisprudence should be. And so if they left these things for judges to decide, it's because of Blackstone. Okay, and so there it is. Anyway, so that was foreseeable misuse. If you can foresee people going to misuse your product in some way, and you know this happens all the time. After you've been manufacturing something for a while and people have been buying it, you begin to get letters from people complaining. And some of the complaint might relate to potential injuries or minor injuries. You send somebody a small amount and they forget about it. They just don't make an issue out of it. But then somebody might have an issue where it's a big issue and they might sue you for it. Now you might say, well, they were misusing the product. Well, the question then becomes, was it foreseeable misuse? Did you do anything in advertising the product that would cause them to misuse the product? We saw that in other cases involving a truck and a Jeep. Now that you know that people are misusing the product in this way and that they can be injured in the process, do you have an obligation to maybe notify them of the danger, maybe recall even the products that they have, maybe modify the product? As I talked about that lamp that I used to have that had a very hot a very hot bulb that would catch drapes on fire when they were thrown up into the lamp by usually children playing around. And so some people would be just horsing around, and the drapes would wind up inside the top, the lamp, which was open at the top, and you had this very hot bulb there that was going to actually start this oftentimes synthetic material fire. and this might do a lot of damage to your house, especially if you didn't know what was happening. And so they issued a recall, and they also told people that they could either bring in the lamp or they could ask for a grill that they could put on the lamp. I asked for a grill because I liked the lamp. It was perfect for my purposes. And, I never got a grill. Although I applied for one, filled out the paper, sent it through the store in, nothing. And so you'll need to make sure that you're following through on those things if you're going to use these, because whether or not you followed through on them or not is a question that might make you liable. Anyway, misuse, foreseeable and unforeseeable. Well, we talked about that. Okay, statutory defenses. We already talked about the first one, which is comparative fault. So like I said, Indiana has that. And you can assert these defenses against strict liability cases as well as against negligence cases. So many states will have those kinds of statutes. At common law, many common law courts say this is strict liability, so we're not going to consider comparative fault, or we're not going to consider contributory negligence. Statutes of limitations. Statutes of limitations are the period of time in which you must bring an action. In the case of torts, oftentimes they're short, maybe a year, maybe 2 years, maybe 4 years. That would be a long one for many torts. Why are they so short? That's because the evidence tends to change quickly over the years. The injury, you want to be able to examine the person's injury. And so if you have a car accident and you tell the insurance company that they ask you, well, were you injured? And you say, well, I've got a blood blister on one finger that was caught as the steering wheel rammed into the dashboard. That's all I've got, just a blood blister. They'll send you to the hospital because they want to examine that and see that it's not worse than you're saying it is, or that you're not going to at some later date claim worse injuries. They're going to want to examine that injury. So you need to actually, if you're going to bring a case, you would need to bring it within a certain time period. Evidence tends to disappear over time. Some evidence disappears quicker than other evidence, so consequently with torts, you need to do it in a relatively short period of time. 2 years is a very common statute of limitations. And so there are statute of limitations to any cause of action, whether you're bringing an action for property or an action under contracts. There are statutes of limitations that has to be brought. Statutes of repose. These are a little different than statute of limitations, and they're also similar. Statutes of repose say that, say that you bought a lawnmower 20 years ago, and now you, are injured by that lawnmower, and it's 20 years old. You didn't have a warranty that lasted 20 years. Maybe you had no warranty at all. Anyway, so I'm sure you didn't have a warranty that lasted 20 years. Statutes of repose say that after a certain period after time for certain products, you can no longer bring a case. And so that you might say, well, how's that different than statute of limitations? Isn't that the same thing? It's more like a statute of limitations. The injury occurred 20 years ago, okay? And after 2 years, you can't do it. So that would be a statute of limitation. You can't do it after 2 years. Now, it's just not a matter of shortness of time. It's that, basically, in this case, you weren't injured 20 years ago. You were injured this year, and now you want to sue, and you're within the 2-year statute of limitation period because the injury just occurred, and you can't do it because of the statute of repose. So sometimes there are statutes of repose to do this. That's, I wanted to talk about a curious kind of argument, a fictitious, actual, what do they call them? Fictitious story that people bring up, and it was totally fabricated. There's this story about people losing their fingers because they lifted up their lawnmower housing with their hands and stuck them into the housing and had their fingers chopped off. This is apparently totally a vicious rumor. It never really happened. People have tried to trace it down. It's only been traced to one source, and that one source was an insurance exec who wanted to, was presenting a speech in which he was trying to portray how silly some of these court decisions are and these juries are, that they would give this kind of a judgment. He was posing this. He had no case to back it up. He just thought it made a good story, and he said he got a good laugh at it. But and, you know, so people like to hear how stupid people have been injured badly. but apparently in this case it was totally what do they call that? It was sort of like the baby on top of the car, right? It's just a completely fabricated story. That it sounds kind of funny when you hear it. You think, well, how stupid are people? And apparently people aren't as stupid as sometimes they're made out to be. Anyway, so that was a totally different thing. So yes, if you did pick up the housing of a lawnmower and injured yourself, or you stuck your hand in the hole where the grass comes out, or when the engine is running, you're going to be injured, and it's going to be contributory negligence. It's a stupid thing to do, an unreasonable assumption of risk, and misuse of the product. I'm sure the products all indicate now that you're not to do that. All the directions on all the lawnmowers I've ever seen have that in their thing. So as a child, when I was 12, I started cutting grass, and I was using different people's lawnmowers, and so they would invariably, they would for some reason hand me their thing and tell me to read it. You know, they were worried about that I might do something silly, and they would tell me also, don't put your hands in there. I said, well, look, I wasn't intending to. But I guess they thought I was just a young, stupid kid. And I was a young, stupid kid, but I wasn't that stupid. So anyway, statutes of repose. Different than statutes of limitations. You should sometimes find those. And these are state statutes. All these are state statutes. Conformance with a safety standard. This is a defense. Sometimes it works. It's more like the defense of misuse, or the defense of you know, anything. You know, conformance with a safety standard, like waiver. You know, basically most products are inspected by the federal government for safety. So there are standards that you have to have. You have to make children's underwear and pajamas fireproof. Okay, you don't have to make the adults' pajamas fireproof, but you have to do that with child's, because there's a statute and there's administrative regulations to enforce that statute. And so if you've conformed with the safety standard, is that going to protect you? Well, if in fact you've conformed with it, it should, if the injury rose from the kind of thing that was the safety standard was to prevent. In this case, you know, protected the child maybe to some degree from fire. Obviously, it might not be totally able to protect the child from fire. It's just that at least the pajamas didn't catch fire. Okay, as long as the pajamas don't catch fire, then you know you can't say that the manufacturer of the pajamas was at fault if the child's toes got burnt. Maybe you want to go after the slipper manufacturer. but I don't know if they have a rule for slippers. Anyway, but you know, it's like what was the cause of the injury? So we'll get back to proximate cause. So a lot of sometimes defenses sound pretty good, except if they're going to be asserted in regard to certain causes. You know, and there are other causes that might be available. The jury might find something else to have occurred that, you know, the pajama couldn't protect you from. So yeah, conformance with a safety standard. You can bring it in, and for what it's worth, it'll as long as the product did what it was supposed to do, you haven't got a case based on that. I mean, you're not going to have a defense based on it conformed to the safety standard. The pajamas didn't burn. The child did. You know, the child in the pajamas can't burn. So that's not the pajamas manufacturer's fault. So conformance with a safety standard. And so it's obviously important for you to comply with those, even if there isn't any safety standard. I once was approached by a man who wanted some advice. He was apparently, he and his wife were making, by themselves, they had started a business making jewelry for infants, infants, babies, jewelry for babies, and wanted to know whether he should be aware of any legal problems that might arise. I said, well, yeah, I can think of one right away. Infants oftentimes put everything into their mouth, Are you producing things like rings and small beads and things that could be swallowed by the child? A lot of that may not injure the child. My sister Nancy swallowed a dime. And I was there and she swallowed a dime. Later it came out in the poop. She saw it. I don't know if she retrieved it. but yeah. Yeah, children will do that. In some cases it might not be so bad. I mean, you might not be so lucky. The child may actually, they may get lodged in their throat, may cut their throat some way, and so you need to be aware of that. So you need to put, you probably want to put warnings on there, and you might want to check into getting some sort of insurance to cover you if you get sued, so that the insurer will pay for your attorney to defend you. You want him to defend you because, I mean, you want your reputation unburdened. And you know, if you do get calls, you want to respond to them promptly and try to resolve it, because you don't want your reputation being injured either. And also, many people will not sue if they feel that the manufacturer has tried to make it right for them. You know, there are two things I think that causes people to sue. How great was the damage? If it's not a lot of damage, people will oftentimes not sue. How serious was the injury? What were the results? Was there some sort of horrible thing? Was the child injured in a bad way? You know, if the child's dead, then that's another kind of problem. So, and also, how did you respond when you were told that they had this problem with your product? You need to be prepared to, you know, do a good job with your PR, your public relations in that regard. Okay, let's see, we've got a couple more here. I think it maybe actually, we already talked about statutes of limitations, so here I define what a statute of limitation limits the time for suits to be filed, to either fix a time after the injury or discovery of the injury. Some states hold a plaintiff to a duty to discover injury within a certain time. That is, they should have discovered it. So for instance, oftentimes the medical profession has, through its lobby, gotten into the books discovery statutes, so that if you have, let's say you have an operation and the doctor unfortunately leaves something in your body that was not supposed to be there. Hopefully it's just something real soft like a rubber tube, or it might be some piece of metal, a clip they shouldn't have left in there. There's a nurse who's supposed to keep track of all that, and she doesn't recover everything that went in. Then she should notice, and they should do a rigorous search for that. But occasionally there will be these cases where somebody has a pain 20 years after the operation, and it turns out it was, you know, something that was left in. They could be defeated by a statute of limitations if you didn't discover it within a reasonable period of time, or you know, within the fixed period of time. So this is the power that certain groups will have to impose things like that through state legislatures, who sometimes are more influenced by lobbyists and the things that lobbyists can give them than they are by the possibility of voters voting for them. Okay, and so we got one more slide here, statute of repose. Like I said, we already covered this. Sets an absolute outer limit on the time which the manufacturer can be held liable regardless of injury or discovery of the injury. So I already talked about that. Yes, you bought the lawnmower 20 years ago. It worked fine. Now it's caused some problem. You think it's a design defect that was maybe there, always there, but never had caused any problem for you. Maybe you found out other people had problems with it over the years, but now it's 20 years later, and you can't bring the suit because it's of a statute of repose that says you have to bring it within 20 years. Don't pick up that lawnmower by the housing, by the way. Okay, that's pretty much it for today, except I will mention that in the next class we're going to be getting into criminal liability. Now we talked a little bit about that when we talked about dogs, but in the next lecture we will talk about that. I haven't talked much about criminal liability. I usually talk more about it, but we'll cover it in that last class. And on Friday we're going to have a test. And in the meantime, there's a it should be posted on Monday, on today, the time that this video is being posted. Also, there's another posting for a quiz, and you might want to take that quiz just do Wednesday. And it should maybe help you prepare you, because I've put in there important issues that maybe you should know you know, so it'll draw your attention to kind of things that I think are important, at least to some extent. And so do that quiz. It'll help you with your studying for the test. Well, like I said, Friday we'll have the test. Be prepared. Okay, thank you very much.